Welcome to Rock Center Shorts. I'm Kristen Savell, Co-Executive Director at the Rock Center for Corporate Governance at Stanford. Today, we're going to talk about discrimination claims related to corporate diversity, equity, and inclusion initiatives, and specifically what recent guidance from the Equal Employment Opportunity Commission, or EEOC, tells us about when corporate DEI initiatives might be unlawful under Title VII of the 1964 Civil Rights Act. My guest today is Katherine Smith. Katherine's a partner in the Los Angeles office of Gibson, Dunn, and Crutcher and serves as co-chair of the firm's Labor and Employment Practice Group. Katherine represents employers in high-stakes employment lawsuits and government investigations and advises employers on all aspects of employment law. She's been named a top labor and employment attorney by Chambers USA, US Legal 500, Law Dragon, Benchmark Litigation, and the Los Angeles Business Journal. Welcome, Katherine.
Thank you. Happy to be here.
Happy to have you. To kick things off, I'm hoping you can give us a brief overview of Title VII of the 1964 Civil Rights Act, including what Title VII does, which entities must comply, and who is protected by the statute.
Sure. So Title VII prohibits discrimination in the terms, conditions, or privileges of employment because of an individual's race, religion, national origin, or sex. This has traditionally included employment actions like hiring or firing, pay, promotion, demotion, retirement plans, leave, and benefits. It generally applies to any private employer with 15 or more employees. And it also protects applicants as well as employees and applies to members of both minority and majority groups, meaning both discrimination and quote unquote reverse discrimination.
And who enforces Title VII?
The EEOC is the federal agency tasked with enforcing Title VII against private sector employers. The DOJ enforces Title VII as it relates to state and local governments. And of course, private plaintiffs are perhaps the most numerous enforcers. Once the EEOC has concluded its investigation of a claim and issued a right to sue letter, a private plaintiff can sue for violations of Title VII.
And what is required to prove discrimination under Title VII?
Well, there are several elements to a Title VII claim, but perhaps the most relevant right now is what kind of employment action will constitute a violation of Title VII. So in a recent Supreme Court case, Muldrow versus City of St. Louis came out in 2023, the court held that a plaintiff must show some injury or some harm affecting the terms or conditions of employment. The court there explained that Title VII prohibits worse treatment based on a protected characteristic, but it doesn't matter how much worse someone has been treated. The worst treatment, even if not significantly worse, that's the harm or injury. So in Muldrow, the court found that a job transfer could be an adverse employment action, even where the employee's rank and pay remained the same, but the responsibilities, perks, and schedules did not. In light of Muldrow, many people are saying that far more things could constitute adverse employment actions, such as failure to participate in a particular mentoring program or something like that. Whether that will actually constitute an adverse employment action will have to be determined by the courts.
Great, and we're going to jump into some of that in just a minute, but I want to talk very quickly about reverse discrimination claims, which you referenced earlier. Those involve a plaintiff from an overrepresented group rather than an underrepresented group, as you mentioned. Does the same standard of proof apply in reverse discrimination claims?
For many years, federal courts have held that majority group plaintiffs must meet a higher standard to prove discrimination, a higher standard than what minority group plaintiffs must prove. That meant pointing to some background circumstances that showed that, and this is the court's language, the defendant is that unusual employer who discriminates against the majority. But the validity of that analysis is currently before the Supreme Court in a case called Ames versus Ohio Youth Services. That case was argued in February of this year, and we can expect a decision later this year. Many commentators believe that based on the makeup of the court and the response of the justices during oral arguments, the court will side with the plaintiff and strike down the background circumstances requirement. But of course, we never know until the decision comes out. And the EEOC has already expressed its opinion that there is no higher standard that should apply to a majority plaintiff.
Okay, it's great to have this background on Title VII because on March 19th, the EEOC issued guidance along with a technical assistance document that was released jointly with the Department of Justice. The two documents address DEI-related discrimination at work and are designed, and here I'm quoting the EEOC press release, to help educate the public about how well-established civil rights rules apply to employment policies, programs, and practices, including those labeled or framed as DEI, end quote. Going forward, I'm going to refer to these documents collectively as the EEOC guidance. Katherine, at a high level, what does the guidance say?
So this guidance reflects the broader enforcement priorities we're seeing out of the new administration. In fact, it would be wrong to start with this guidance and not talk about what preceded with, which is the executive order issued by the Trump administration on Inauguration Day. That order, titled Ending Radical and Wasteful Government DEI Programs and Preferencing, directed the termination of all DEI programs, policies, and activities in the federal government. While that EO related to federal agencies, it previewed what will be coming for private employers as to how federal agencies apply the law. So then on March 19th, the EEOC issued the guidance that you just referred to, which includes 11 questions and corresponding answers. So it's in an FAQ form, addressing the process for asserting a discrimination claim and the scope of protections under Title VII as they relate to DEI programs. The guidance emphasizes that Title VII's protections apply equally to all workers, regardless of whether they are part of a majority or minority group. It states that in the EEOC's view, there is no such thing as reverse discrimination. There's only discrimination. So in this guidance, we're seeing a new approach to DEI from this administration, which is a view that it is the potential cause of discrimination in the workplace rather than a potential solution to discrimination in the workplace, which is how the EEOC under prior administrations had generally described it.
I want to explore in more detail what the guidance tells us about when a DEI initiative, policy, program, or practice is unlawful under Title VII. So the guidance calls out DEI-related disparate treatment, again, whether against an underrepresented or overrepresented applicant or employee, in the context of, as you stated, hiring, firing, promotion, demotion, compensation, or any other term, condition, or privilege of employment. Historically, most employment discrimination lawsuits have focused on things like hiring, firing, promotion, and pay. So I'm not going to dive into those topics in detail, but I do want to ask about a few other terms, conditions, or privileges of employment that the EEOC guidance specifically call out, which may be a bit newer and less well understood, particularly in the DEI context. So for example, the guidance suggests that excluding employees from training, including training characterized as leadership development programs, will violate Title VII if motivated by a protected characteristic. So Katherine, can you explain when or under what circumstances a corporate training program might violate Title VII, at least according to the EEOC? And to the extent you can provide concrete examples, that is always helpful.
Sure. So most workplace trainings aren't reserved for only some employees, so they're not implicated by this. But the EEOC here is particularly focused on leadership development programs, which some employers may offer to certain groups that may have historically lower promotion or retention rates. Some examples might be, for example, an internal program on how to lead as a woman manager, or an external leadership academy for Black executives. The EEOC would likely say that that violates Title VII, although of course whether a court would agree with that remains to be seen.
The EEOC guidance also suggests that excluding employees from mentoring, sponsorship, or networking programs will violate Title VII if motivated by a protected characteristic. You referenced this earlier. Can you share some examples of the types of mentoring, sponsorship, or networking programs that the EEOC might focus on?
So in the guidance, the EEOC has stated that an employee's success may depend not only on their job duties, but on their integration into important workplace networks. They don't elaborate extensively on what that may mean, but on that basis, the commission has stated that employees of all backgrounds should have access to workplace networks. That should be true as well of mentoring. So the EEOC's view here appears to be that the purpose of networking groups and mentoring is to enhance professional success. But again, whether a court would agree with that and agree that networking groups may be limited to particular members, such as women or LGBTQ plus individuals, whether a court would allow for that or say that the reason for those networking groups is to enhance professional success, I don't know if a court would find that. I think a lot of people would argue that there are other reasons for those networking groups other than just getting ahead in your job. So we're going to have to wait and see how the courts interpret that.
All right, Katherine. In addition to training and mentorship programs, the guidance specifically calls out workplace groups like employee resource groups or other affinity groups that limit membership based on protected characteristics. Can you give some examples of workplace groups that might garner the attention of the EEOC?
Yeah, as a practical matter, many employers don't limit the membership of their ERGs at all, so it's not necessarily what the EEOC is focused on here. But those that do limit membership generally do so to provide safe spaces for particular demographic groups, such as LGBTQ plus individuals may have a group that exists only for the individuals that identify as such. Notably, most employers that have a group that is reserved for LGBTQ plus individuals also have a group that is broader, that it would include allies. But as to these more limited groups, the EEOC would say they violate Title VII and would presumably say there's no need for segregated safe spaces. Again, whether that actually reaches the standard that has been set forth in Muldrow, we'll have to wait and see. But I think there's a lot of arguments for why that would not constitute an adverse employment action.
A lot of ambiguity here.
A lot of wait and sees.
Right. Many people in the audience will be familiar with the NFL's Rooney Rule, which requires teams to interview at least one candidate from an underrepresented group for head coaching positions. It was later expanded to include front office positions as well. The Rooney Rule has gained traction in corporate America over the past decade, with many companies adopting variations of the Rooney Rule to ensure diverse candidate slates. However, the EEOC guidance indicates that selecting applicants for interviews based on a protected characteristic would violate Title VII, and that includes both excluding or including an applicant in a candidate slate or pool. So, Katherine, what does this guidance mean for the Rooney Rule going forward, and also for the many companies that are committed to ensuring more inclusive recruitment and hiring practices?
So, as you say, the Rooney Rule was adopted by the NFL in 2003, and many private companies took that Rooney Rule and ran with it and applied something similar within their ranks, including policies based off the Rooney Rule requiring a certain number of diverse candidates on interview slates. Now, the EEOC has taken the position that selecting or excluding a candidate from consideration based on a protected characteristic would violate Title VII. But worth noting, recent comments from NFL Commissioner Robert Goodell indicate the NFL remains committed to the Rooney Rule, and we expect that many employers will argue that diverse slate programs are not discriminatory. To the extent they are only adding additional candidates to the mix for consideration, they're not working against anyone.
That's helpful. Can a corporate DEI policy or practice give rise to a hostile work environment, which can also form the basis for a Title VII claim? And if so, when might that occur?
Title VII prohibits workplace harassment. That can occur when an employee is subjected to unwelcome remarks or conduct based on race or sex or some other protected characteristic. And again, it doesn't matter if you're in the majority group or the minority group, you can still be harassed. According to the EEOC, an employee may be able to plausibly allege or prove that a DEI-related training can create a hostile work environment. And they say that a plaintiff can do that by showing that the training was discriminatory in content, application, or context. However, to be actionable, harassment must be severe or pervasive. That's the standard. And it would be a very rare training that was so severe that it rose to the level of illegal harassment. And in my experience, DEI programs are generally not so pervasive that they affect an employee day to day. So this too is something that we will have to wait and see how it plays out in the courts. But to me, I think this will be a harder sell to find a training that constitutes actionable harassment.
And are there any affirmative defenses to Title VII that an employer could point to in support of a DEI initiative?
Title VII allows employers to raise a bona fide occupational qualification as an affirmative defense in limited circumstances. However, that is going to be a very limited space. But more broadly, I expect many employers will challenge the fundamental notion that the existence of a DEI program or policy results in worse treatment to any particular individual. And that's kind of what I've been getting at all along. This is being tested in the courts right now as people start to challenge DEI programs and policies. For example, a Georgia district court recently noted that generally the mere existence of a diversity policy without more is insufficient to plead discrimination under Title VII. So it can't just be a policy in a vacuum. The mere existence of the policy is not enough. There also have to be evidence supporting the elements of a Title VII claim.
All right, Katherine, last question for you. What key steps should companies be taking now to ensure that their programs, policies, and practices are aligned with the new EEOC guidance?
So employers may want to take a hard look at their policies and practices in light of the EEOC's guidance, preferably with counsel. We've seen a lot of employers engaging in audits of their practices since the Harvard admissions case in 2023, which first brought significant attention to affirmative action issues. And many have revisited and re-audited with the issuance of the most recent executive orders and EEOC guidance. Employers may want to look particularly at any programs that are not open to all employees to evaluate the reason and risk of such programs. They may want to review training, mentoring, and recruiting programs as well. And critically, they want to think about and be thoughtful in how these changes are implemented and communicated to their workforces, because we know employees are watching what's happening these days and they're really paying attention. But perhaps most importantly, if there's been one theme of everything I've been saying, employers should stay tuned, because the law in this area is still developing and we're seeing rapid movement from this administration. And we're expecting that things will continue to develop, and all of that may inform an employer's approach to DEI. So keep your ears and eyes open.
All right, it sounds like we're going to have to continue this conversation once the courts have had a chance to weigh in.
Sounds good.
Thank you, Katherine. I appreciate you sharing your insights with us today. And thanks to everyone in the audience for tuning in. I will see you next time.
Thank you.